Yeah! You know who it is. Hey, don't ask who did it. Check the name, fool. The associates did it, yeah, they rolling deep. The associates did it, got it out the streets. The associates.
Hey, hello everybody. This is Josh Carpenter from Carpenter and Associates, and I'm coming to you with a case study this morning. We're going to talk about, and I'm going to read you kind of the background of this case study, and then we're going to break it down and kind of go from there for you later as a group. So I just wanted to give you the background. Let me see if I can pull this up, and hopefully we can just kind of keep things rolling for us here. All right, so this case, the names, places, everything has been changed and modified. None of this is the original locations, names, incidents, and everything. So this is just to give kind of a context of things. This was written and narrated by me, Josh Carpenter. So I can promise you it's completely fictitious. We just used information from other cases that may or may not be relevant, excuse me. All right, so this is the story of a Texas divorce and custody case that unfolded for our purposes in Collin County, Texas in 2024. It involves addiction, grandparents, therapists, and the hard choices that the court sometimes has to make in the name of the infamous test of the best interests of the child. So here we go. John and Melissa Harper married in 2012. For several years, they did what young families do in North Texas. They bought a modest home, built careers, and had a daughter named Avery in 2016. John worked as an electrician for a Department of Defense contractor, and Melissa was a dental assistant at a relatively successful practice. They struggled financially sometimes, but nothing that looked anything unusual from anybody on the outside or to anybody else for that matter. Things changed, however, after Melissa was in a car accident involving soft tissue damage in 2019. The injuries technically were minor, but she was prescribed opioids for the pain. And like so many others before her, what started as a short-term prescription slowly became a long-term dependence. When the prescriptions ran out, the pills did not. And over time, the pills gave way to other drugs of preferences, like methamphetamines and other stimulants that kept her awake for days at a time. By 2022, Melissa was no longer working. John was carrying the financial and emotional weight of the household, and arguments became shouting matches, and shouting matches became police welfare checks and interventions called in by neighbors and family. Melissa's parents, the Thompsons, lived nearby, and they began quietly managing more and more of Avery's day-to-day life. Rides to preschool, lunch money, weekend babysitting, extracurricular activities. And what they didn't realize at first was that they were also becoming key witnesses to the unraveling of the marriage. By January of 2024, after a particularly chaotic episode in which police were called to the home at 2 a.m., John decided he finally could not do it anymore. He filed for divorce, and the case was assigned to the 469th District Court in Collin County, and he cited insupportability and requested to be the parent with the exclusive right to designate Avery's primary residence. John wanted primary custody. Melissa did not take this lying down. She countered and asked to be named the primary parent instead. She accused John of being controlling, angry, and emotionally and physically abusive. But these claims in the end would never be substantiated by the court. Both sides requested temporary orders. At the first temporary orders hearing, the judge listened to both parents, reviewed police reports from the welfare checks, and looked at Melissa's recent drug history. The judge ordered drug testing, appointed an amicus attorney to represent Avery's interests, and temporarily restricted Melissa's visitation to supervised periods until testing and treatment were addressed. John became the day-to-day parent almost overnight. Avery was 7 years old. She did not understand addiction, but she understood all too well chaos. She understood fear, and she understood that sometimes grown-ups cry in cars. She had a child-sized vocabulary for a very adult problem. Over the next 2 months, Melissa tested positive for methamphetamines and entered a 60-day outpatient program by court order. She requested expanded visitation while in treatment, but the amicus attorney recommended against it until sobriety was more fully established. During this same period, Avery began displaying signs of anxiety. She had severe stomach aches, clinginess, difficulty at school, and her grades were suffering. John found a licensed child therapist who specialized in trauma and adjustment disorders, and Avery began weekly sessions, and the therapist quickly became, and quietly became, one of the most important figures in the case and to the child. The amicus attorney recognized early that this case was not going to be resolved by simple mediation. With competing allegations, addiction, and a highly involved set of grandparents in the background, the amicus moved for a formal custody evaluation under Chapter 107 of the Texas Family Code. The judge granted it. Custody evaluations are long, invasive, highly detailed, and highly expensive. This one included home studies, psychological testing for both parents, collateral interviews, drug compliance checks, and supervised parent-child visits. The early notes from the evaluator were cautious but telling, in that Avery was strongly bonded to her father and extremely sensitive to her mother's unreliability and unpredictability. About halfway through the custody evaluation, Melissa's parents, Avery's maternal grandparents, made their move. They filed a petition to intervene, asking the court to name them possessory conservators, or at a minimum, grant them structured visitation rights under the Texas Grandparent Access Statute. Their argument was heartfelt and polished, and they had been caring for Avery for months during Melissa's decline, and they had developed a substantial parenting relationship with her, and they feared losing her entirely. John moved to strike the intervention, arguing that grandparents did not have standing, that he was not unfit, and that the parental presumption doctrine applied, which meant that the case was between him and Melissa, not him and the grandparents. The judge allowed the grandparents to stay in the case, but did not make any decisions yet about possession or access. Meanwhile, the child therapist continued working with Avery and eventually produced a written summary for the amicus attorney. The summary noted Avery's anxiety, her stated fear that her mother might get mad and throw things, and her confusion about whether mommy was sick or angry. The therapist did not make placement recommendations, because Texas law is cautious about that with therapists, but facts did in fact matter. And these were the kind of facts that shaped the best interest of the child analysis under Texas case law. 6 months after the divorce was filed, the custody evaluation reached its conclusion. The evaluator recommended joint managing conservatorship, John as the primary parent with the right to designate Avery's residence and school, Melissa having possessory conservatorship, and she would have possession on a graduated step-up plan dependent on continued sobriety and drug testing. The parents also would receive structured visitation twice per month to maintain their relationship with the child. It was all a compromise that reflected the messy humanity of the situation and the law's preference for stability, as well as following the parental preference doctrine. The final hearing took place in November of 2024. It lasted multiple days. The evaluator testified, the therapist testified. Melissa's mother cried on the stand as she described buying school clothes and paying for speech therapy lessons. Melissa herself testified that she had been sober for over 120 days and was continuing in her aftercare and treatment. John testified about the toll everything had taken on Avery and on himself. When it was all over, the amicus attorney told the judge that she agreed with the custody evaluator's recommendations. The judge signed the orders naming both parents joint managing conservators, but giving John the exclusive right to designate primary residence. Melissa was ordered into a sobriety-paced visitation plan, and the grandparents received 6 hours of structured visitation twice per month. Therapy continued until the end of school, and just like that, the marriage was dissolved. The rights were assigned, and the schedules were inked. The future, as it always is in family law, was left open for modification. So the aftermath of this case, we'll analyze more in depth, but people like to believe that court orders settle everything, but in family law, they usually just establish the rules for the next chapter or next confrontation. It is the floor, not the ceiling, that is typically established. Melissa could relapse, or she could fully recover and become an extraordinary mother yet again. The grandparents might eventually fade out of the picture, or they might become co-parents in everything but name. Avery might grow out of her anxiety, or she might carry it for years. Texas law does not guarantee perfect outcomes. It aims and tries to obtain the best interests of the child in a landscape where adults are often doing either their best or their worst. This was the Harper case, one of thousands, tens of thousands filed across Texas every year, each with its own quiet collisions between addiction, loyalty, family, and the law. And we will be breaking it down more in depth together and seeing what people think about this case. So we'll be right back. Good afternoon, everybody. This is Josh Carpenter of Carpenter Associates, and welcome. You've just listened to a narrative on a made-up case that actually brings up a few different points we're going to discuss today. But before we get to that, we're going to go around the room and introduce everybody.
Howdy, this is Brian Sherman.
This is James Metcalf.
Todd Cohen.
All right, so I had read at a different time, and we're kind of splicing things together.
I was going to say, your costume change was quick.
It was very fast. I did have a fantastic Finding Nemo shirt on though, so I was happy about that. All right, so what we're doing today is a little bit different. We're still trying to find the sweet spot with some technology issues, and so if anybody has issues with mics or sound quality or anything else and knows how we can improve or better software or editing, like whatever, please feel free to reach out. We're lawyers, we're not audio engineers and everything else. And
Nor
so
are we thin-skinned.
yeah, and we can take the abuse. I mean, we have to, consider all things considering. Just want to give kind of a State of the Union. It is the new year. This is the first big episode of the new year, I believe. And 2026, we have a number of goals, both individually for the firm and even for the podcast. We're going to be bringing in client guests and people with different types of family law cases, small business owners, and all sorts of other fun stuff that we're getting lined up. And so we're pretty excited about that. And hopefully we can always learn to make things bigger and better. And without much more to do, let's get started. So I think everybody's read this, and hopefully you've just listened to the narrative, and we'll just start from the beginning at this point. So we have this marriage. They were married for a while. Mom has a drug issue, grandparents get involved, everybody gets involved. And first and foremost, I think Brian's the only one that doesn't have a ton of family law experience, and it's important that he's in here to he is a trial attorney, but this is different than a typical trial. So we definitely want that point of view. So what is everybody's initial thoughts as they've gone over this case, if they've heard it and everything else? Does anybody have anything that stands out?
I'm not sure about stands out just yet, but I know that if I had to write this in family law during law school, I would be so mad at the professor, because there's not enough time they give you to write the essay to respond to this narrative.
Right.
Because there's grandparent rights, there's amicus rights,
Yep.
there's the parents' rights again.
But then what's crazy is like how realistic it is in practice.
Yeah.
Well, I wrote this, just to be clear, and I wasn't trying to do a law school thing. I just wanted to touch on very specific things that we get to deal with a lot. And so, first and foremost, if everybody has not seen the movie Divorce Corp, it's a movie, I believe it's on Netflix. It's an important thing to understand whenever you're practicing family law. And Divorce Corp specifically talks about custody evaluations and the development of family law practice throughout the country, but it actually weirdly focuses on the Dallas community. That's where it starts. And one of the reasons is Dallas was kind of a pioneer test subject of custody evaluations, and custody evaluations are ungodly expensive. And so for civil trials, you have experts that you can fight back and forth with. So Brian, if you, let's just use something, we'll call it simple. Let's just use a simple traffic accident. How important is an expert in a traffic accident case?
Well, an expert's going to give you your causation. Just because you have an accident and just because you have maybe an injured person, that doesn't necessarily mean that they're causally connected, and it doesn't mean that the actions of one cause the injury of another. And so we are laymen, all of us, and so you need people that are scientifically trained and have the proper background to be proven up as experts that can actually explain how one event happened and how it impacted the other.
So it has to be somebody with whatever expertise, whether it's, accident reconstruction is a very broad term, but
somebody that can prove skid marks, type of tires, everything else, that Brian's actions directly caused the injuries of James, for example.
Right.
So that expert is the person who has to be able to prove that, because lots of people can guess, but we don't know.
Right. So, for example, what if you had somebody that already had a broken arm in the car, and all of a sudden that arm is worsened? It's still broken, and it started out broken, but to
now
what
it's really
extent-
broken.
But now it's really broken. So, all kinds of strange issues can arise when you're talking about causation and sort of the state of how the scene looked prior to the impact, and then what it looked like after, including all the injuries that might have resulted from that accident.
And it can even go as well as like if the brakes needed to be fixed, and it's like, well, I stopped immediately and I put it on immediately. Yes, but you're also put on notice to fix the brakes. You didn't do it for whatever reason. Now we have a whole nother issue.
Right.
And yeah, I know it from a layman's standpoint. I know it would suck because experts aren't cheap, but from a judge's standpoint, they don't know you from Adam. So you have to really tee it up to make it as easy as possible, or for a jury to decide this is in fact what happened, or I give better credit this way or that way. It's
Well, and also you have comparative responsibility here in Texas, and so you have to be able to apportion amounts of liability amongst all the parties.
All right,
in order to
so
gain recovery.
applying that to a family law custody evaluator is the same thing, right? And whether we right, wrong, or indifferent, I know a lot of people, especially a lot of lawyers and families, have very strong opinions about custody evaluators. And not to toot my resume here, but I have a PhD in developmental psychology, right? And so one of the reasons I did that originally was I had planned to do custody evaluations, and I do amicus work, and I do ad litem work, and I do all these things to help kids. But really, I plan to just be able to kind of delve into kids' psyches and the family situation and make recommendations as to, you know, what should happen with these kids ideally. And I do that privately. I get hired, I've been hired by different jurisdictions, different people in other states. I've been tendered as an expert in 5 different states for the effects of domestic violence in a custody case. And so I've been able to do that, and because of my law enforcement background, a bilingual, and my psychology background, not to mention a couple decades of practicing family law, I've been able to do that and make those recommendations to the court and kind of go from there in these different cases and jurisdictions. But what's so tricky about that is this is the X factor, right? So a custody evaluation, when you're talking about kids, it still depends on a human factor.
right.
And so let's just say, in the case at hand here, let's just say the custody evaluator, it doesn't talk about this, but we're going to talk a little bit about how the human factor affects these cases that are like this. So in this case, we have the mom, she's had drug issues, dad's been carrying the weight of everything, and mom has supervised visitation, the court appoints an amicus, the amicus requests a custody evaluation, right? Before we even get to all that, it's important to understand, in family law especially, all of this costs an insane amount of money.
Right.
All right. So you have your average attorney retainer, and we're just going to say $5,000 because I'm terrible at math and that's an easy number, right? So let's just say somebody comes in and they have to pay $5,000 retainer for their family law attorney, or even if it's not 5, they're going to be spending more than that, more likely.
Yeah.
And in a case like this, you're looking
It's
at
contested, so it's gonna be spending more. Yeah.
in a contested case like the one that's outlined. This is a very expensive case, very expensive.
For both parties.
Because you have the attorneys, both parties have their own attorneys. They have the amicus attorney who charges just as much. It's a regular attorney on behalf of the child.
Just explain for the listeners what an amicus is.
Yeah, so an amicus is an attorney that is appointed to look after the best interest of the child specifically. So it's the court basically hires an attorney for the child, right? And so
I mean, even here, even in the fact pattern that you created, I mean, the amicus, you know, had a meeting with the child to really understand. And it ends up here. Avery was strongly bonded to her father, but extremely sensitive to her mother's unpredictability.
Right.
So like, okay, through the evaluation they got there, and like you said, human factor may not be perfect, but that's what the child's telling her at this, what was it, that she's 7 years old, correct?
Right.
And so the 7-year-old level, she's trying to understand it the best way that she can relay that to the amicus. The amicus is relaying that back. And yeah, that ain't gonna be cheap either.
yeah, and so I think people just need to generally understand, like an amicus charges just as much as a regular attorney. And then if you get a custody evaluation, that's typically 10 grand. And so realistically, you're looking already just at the outset of this case, you're looking at over $20,000 expended per party. Easily.
And Josh, who pays for the amicus?
The parties do.
Both.
Both the parties pay for the amicus, and both the parties pay for the custody evaluation.
So this is different than like a court-appointed ad litem.
Right.
Okay.
And so that's an important factor to understand here, because a lot of people, the stereotypical, if you look at this fact pattern, mom was a stay-at-home mom at this point, right?
Mm-hmm.
Like she got hurt, she was a CNA before she got hurt, and then she got addicted to drugs to tend to her injuries. And so dad was bearing the burden of going to work, taking care of everything. It would appear, for a right, wrong, or indifferent, it would appear that the grandparents stepped in and they were providing daycare and doing everything else. And then, so you have this grandparent component where they're providing a lot of the parenting. Dad's going to work and coming home and taking care of this little girl, and mom is high half the time, right? And so what you're dealing with is all of this different parenting issues and everything else. And so what often happens is, let's say mom comes in and she says, oh, I don't have the money for an amicus, or I don't have the money for a custody evaluator. Can we file a motion to get that equalized? And the typical answer, of course, is, we're going to try, but oftentimes the courts will take that into account. They'll take the cost into account, but she's still going to be responsible for something. Nobody's going to be allowed to just skate, right? And even if the husband has to pay everything up front, subject to reallocation, that'll typically come out of the division of the community estate at the end of the case. And so money is a tricky thing in family law cases, because more often than not, it's very lopsided, right? And so there are very, very few families where each party makes the exact same amount of money, and they have equal access to money, equal access to resources. And so a lot of people that are out there listening, or that know friends or family going through these things, one of the questions is always going to be, how do I afford this?
Right.
And right up front, there is no right to an attorney in a family law case, period.
That's why you see a lot of pro se's in family law court.
Right. And so you have to understand, it's not easy either. And so we tell people all the time, this is your chance. You're fighting for your family. I'm not trying to use fear factors or anything here, but you're fighting for your family. And so if you want to get into a fair fight, and if you want to do things right, call in favors, find the money, do whatever you can. I mean, we've had client after client after client, year after year, that they'll tell you flat out, even people on our staff that have gone through these cases, they will tell you they've done everything humanly possible to make sure they have money to be able to have somebody fighting on their side. And so you have to get that money. You have to find it somehow. Friends, family. I've seen people do group me. I've seen people do anything. What was that?
Loans.
Yeah, I've seen people do loans. Like, we offer financing, right? It's through our credit card processing company. It actually has nothing to do with us, but that's been something that's become very popular over the last year. Is people will call in, they'll talk to our finance manager, and they'll say, Amy, I don't have the money to put down. And she'll say, well, we have this program through our credit card processing company. You can apply, and they'll give you the retaining money and things like that. So that's a relatively new program within the last year that's been set up. Before that, there aren't a lot of companies that are going to give you a loan, or banks. You can take out a personal loan. You can do things like that. You can take loans against retirement, whatever the case is, but you have to find that money somehow.
Oh yeah, I mean, when I was in law school, I interned at a place called DVAP, which stands for Dallas Volunteer Attorneys Program, and a majority of what they would handle is our divorces or wills, and the divorces were $50,000 or less, but they would take a huge reduced rate, and the majority of those who were getting divorced were people that had been separated for years because they didn't have the money to get a formal divorce. So they just said, you go over there, I'll go over here, we'll do our own thing, because it was a whole lot cheaper for them because they couldn't afford it.
Yeah.
And now they're saying, well, I've met the guy, or I've met a new gal, and I want to make this legit, and I want to get married, but I have to formally end this marriage. The person's not going to contest it. We've been separated for 10 years now. Our money has been separated, so we just need to straight up just give me the legal papers so I can say I'm divorced, so I can get married, because of all these factors you just mentioned right here.
Now, we did, in the middle of my rantings, by the way, we did have the presence of Jason Nauman walked in and joined us, so he's here as well. Jason's a longtime family law practitioner
He snuck on in.
He,
Like a ninja.
and so we want to welcome him, and he can just interject whenever he feels like. But so we work past that money issue, which is typically the biggest issue for a lot of people in family law, and then we address the facts, right? And so if I was representing mom, these are tough facts because she's recovering from opioid addiction, meth, and all these things, and she's coming back. She's essentially voluntarily abdicated a lot of her parenting responsibilities to her parents, and the husband has been left holding the bag. Now, ideally, this would be an easy issue. Ideally, all the parents could be adult, and even the grandparents could be adults and say, okay, what do we need to do for what's best for this child, Avery? But in all the cases I've done, that Jason's done, that James has done, Todd's done, Brian's done, it is very, 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 very few and far between the times that people are really willing to come back and say, I'm just going to do what's best for the child. Voluntarily, they don't do that. More often than not, frustratingly, more frustratingly, they use the child or they use custody situations as leverage, which I don't think anybody necessarily approves of, but it's just a fact of life.
I think they just get hyper focused on the litigation side of it. You know, once they're in the process, it becomes almost automatic. It becomes a sense of, I hate to call it a game, but it becomes a sense of the contest. And I think sometimes it's not seeing the forest for the trees. You know, they're like, all right, we've intervened in this case, in grandparents' case. Well, we've got to keep pursuing this to the bitter end, where really maybe at every step of the process or every stage of the process, what they should be doing is stopping and reassessing, is this really benefiting the children, or am I just locked in this litigation mindset?
Well, I think that's the trick. I mean, we talk a lot about, we've talked some about this on this podcast, is the difference between good attorneys and great attorneys. And this is one of those things where there is a lost art in the practice of law, in my opinion, of picking up the phone and talking to people. Brian and I joke about this frequently. In fact, he came in the other day, he's like, I did something a lot of people don't want to do, is I picked up the phone and got the case settled, called opposing counsel, right? And this is the type of case that, had two really good family law attorneys been on this case, they probably could have sat down and ironed this whole thing out and said, look, let's be real about this. Let's put all the personal drama, all the personal feelings aside, and let's just work this out. Realistically, the two attorneys should be able to do that. But that's not always how it happens, and I'm going to tell my version of oftentimes why that happens, and you guys chime in, please, and then we're going to keep moving forward with the rest of this case. I think the business of the practice of law, the business of being a lawyer, changes how a lot of people want to handle cases. And I say that as somebody who, twice now, I have started my own law practice from scratch, right? And I worked it from scratch and grew, fought, bit, scratched, everything, did everything humanly possible to create a living and create something that I can have for a career, and then be able to add and work with people that I genuinely care about, respect, and love, honestly. That's hard. And it's hard also if you don't know how to bring business through the door, if you don't understand, you know, like things like court performance and track records really matter in order to bring business through the door. The majority of my cases, when I moved to Texas 8 years ago, the majority of my cases that I got came from people watching me in court. That's it. I didn't have a lot of money at that point. I had left my other practice in New Mexico, and I came to Texas 8 years ago, and I said, okay, I'm going to move here. Everything's better for my family. The schools are better. The community is better. Everything was better, and it's more business friendly. And so I was able to figure out and crack the code a little bit about, okay, I'm going to be able to get clients through the door. But I cheated to a certain extent because I'd already been doing it for 14 years. So I already knew a lot of the tricks of the trade. That's not the same for a lot of other people. So you have a lot of other law firms that are clamoring for business, and especially in Dallas, we've got 20,000 plus attorneys. Who knows how many family law practitioners and business and everything else. Everybody's fighting for business. Realistically, there's more than enough business here.
And then the bar sends out jobs available every
Yeah.
time for their month, like your month in review. It's like, I just have a bar card, but just in case you want to
Yeah.
work with Thomas J. Henry, it's right
Yeah.
here, over and over.
He'll pay you $5 million a month if you can last. You know, it's like the Squid Games half the time at some of these law firms. But and so a lot of the attorneys that you go up against, especially in family law, landlord tenant, some of the less expensive, ideally, less expensive areas to practice, people are fighting for their lives. And so instead of being able to sit down and have a cogent conversation with Jason, what do we need to do to take care of Avery, the daughter in this case? How do we protect our clients? How do we protect this girl? Most of all, what's the right thing to do? Because really, I've known Jason for 5 years now, right? I've seen him handle super complicated cases. I've seen him handle super easy cases. I've known James for a few years now, a couple years now. I've seen him do the same. I've known Todd for 4 years. I've known Brian for a while. Like, I generally know how people are going to handle a case, and I think all of us can sit down, put everybody's pride aside, and say this is what's best. Generally, there's always going to be some tweaking, but generally, it's probably best that the little girl doesn't see, you know, drug addicted behavior and mom freaking out, breaking stuff against the walls and things like that. It's probably best that mom be sober. It's probably best that grandparents don't try to take control and parent over everybody else. It's probably best that we do a lot of things, but if you don't have that opportunity to sit down with another professional lawyer, you're going to have an attorney that's looking at his bills. And people may disagree, you guys may disagree, but just hear me out. You have an attorney that's looking at a bill that they have to pay, whether it's rent, Westlaw subscriptions, payroll, whatever it is. They're looking at their bills and they only have a few clients to cover those bills. It is not easy for them to put all that aside and truly say, this is what's best. Because they're going to go through like, well, this is what I do on every case, and we're gonna fight until we don't have to fight anymore, and then we'll talk settlement. And anymore, because of the tenor of so many family law cases, there are a few things that you almost have to do 100%. We almost have to, and if you don't believe me, we had judges on this podcast that have said this. You have to send out discovery. And there are very, very few exceptions to that. You have to send out discovery. You have to exchange the inventories. You have to exchange all these things because people lie all the time. And so if you don't have attorneys that have good client control, and if you don't have attorneys that have the best interests of the child truly at heart, you're going to fight and you're going to spend $20,000, $30,000, $40,000, $50,000. And if you guys don't believe that, I just won a trial out of state this week. I just won a trial that had been going on for 7 years. I was the 11th law firm on this case. 11th. I wish I was kidding. 11th law firm, 7 years of litigation. I had the case for 1 month and went to trial and won. And it wasn't because I'm the world's best lawyer. It's because I was able to break down the issues to the client and break down the issues to opposing counsel and, thank goodness, break down the issues to the judge and make them simple enough to where all the other superfluous noise that had been going on in this case for years was kind of canceled out. We cut to the meat of everything and we got it done. But that's hard to do in family when you're dealing with lawyers that are scrambling financially, that are scrambling out of pride. Because the other thing that people don't like to talk about, lawyers are kind of prideful.
Just a smidge.
We are competitive and we're prideful. And so you have to be careful when you're dealing with them and when you're dealing with their financial position and everything else, because all of that comes into play. And if somebody says they don't, I will physically fight them. It all has to do with the entire way the cases are managed. And that's why we have people here at our firm that aren't in that position. Like the attorneys here, and I know this is the case with some of the other firms as well, I've intentionally removed the financial aspect from the lawyers. They don't deal with it. So they are just able to lawyer. They're not wearing all the hats of, oh, I'm accounts receivable, I'm collections, I'm doing, no. Here, it's about taking care of the client. Now, I know that's not everywhere. I know a lot of people handle things a lot differently. But as you're going into a case, I think all of this is really important to understand and to look at, because if you're looking at having to pay for a custody evaluation, having to pay for an amicus, and having to pay for supervised visitation or whatever else might come to drug testing, especially in this case, it's all so expensive. And that money's got to come from somewhere. And even if the couple is rich, that money wears them out real quick. Nobody anticipates tens of thousands of dollars going out the door every month. Nobody. I don't care if it's a huge company. I don't care if it's a private billionaire. It's an added cost that's not part of the budget.
And it seems like it's a faucet that's never being closed off.
Yeah.
Just get out every month. Like, well, what this time? Well, we had to do this, this, and this. Why? Because it's in your best interest. We have to protect you. Even if we have a good chance of winning, we still do all, like you said for the discovery, we have to do all these steps. Otherwise, the judge is going to send us back and we restart this entire thing when we could have just done it from the get-go.
Right.
And discovery is the part, I mean, for civil and for family, even though family is civil, it has its kind of own independent thing. That's usually where a huge chunk of costs come from. Is I gotta write them, I gotta get them sent, and then that's a huge expenditure right there. Then the client may get upset because legally, according to the rules, I have to give them 30 days. They can answer them earlier, they're not going to, so you're gonna wait 30 days. Once you get them, were they sufficient now? Now we gotta start that whole process. Now I gotta review everything. That's another huge cost. It gets expensive real quick.
Yeah, but it's part of what has to happen.
Mm-hmm.
So, all right, so on this one, so they go through, they hire everybody, the divorce begins. They go to temporary orders, and the temporary orders, if you're in Collin County, which I fictitiously put this case in Collin County. So Jason, illuminate us, because I think you did a temporary orders hearing this week in Collins County, if I'm not mistaken, but how does that temporary orders hearing work in Collin County, typically?
And explain what a temporary order is.
Thanks,
Put me
Brian.
on the spot. All right, so a temporary order, simply put, is an order that lays the groundwork, establishes the rules for all the things that would normally be included in a final SAPSR order or divorce. Rules that last for the pendency of the litigation. So in this case, you're going to have, things like child support, conservatorship, which is the decision-making authority, and possession and access, which is who has the kids when. Those are going to be the most important things that you're going to cover in a temporary orders hearing. Related to a divorce, you might also be getting into some property issues like spousal support or temporary spousal maintenance, who has exclusive use of the home or cars. But most temporary orders hearings, we're fighting over kid stuff. And what was the other part of the question? Oh, in Collin County, you're going to get 20 minutes aside. Each party's going to get 20 minutes to try to give the court a very brief overview of the facts and
You get a clock right there, don't you? It shows you the clock. So you know
It's a literal chess clock.
most courts have it right up on the wall. Mom, dad, and in this case, intervener, our grandparents. And when you're talking, when you're offering an exhibit, when you're arguing an objection, your timer is clicking off. And 20 minutes goes quick.
Yep. Now, as we're talking about the temporary orders, we talk about the grandparents as well real quick. What is, Jason, or anybody who wants to hop in, what is the typical reaction to a court when grandparents move to intervene? And the child is not living with them full time. The child just has, they were helping with
They live
daycare,
close
stuff like
by,
that.
but they don't actually live with them.
Clarify the question. What?
So do grandparents in Texas have automatic custody rights?
No, they don't.
That threw me off in this type of
I was trying to.
Again, this is a family law school exam.
Yeah, so what is a typical reaction to the court if grandparents, and I'm going to say this very specifically because a lot of people are going to say, well, this happened in my case and this happened in my case. This is a disclaimer. All family cases are different. So before everybody goes relating any cases to anybody else's cases, it's very important to understand that family law, very specifically family law, they're all different. So it's really hard to say, well, this is what should have happened because this is what happened to me. No. So in this case, Jason, the grandparents were just helping. They actually helped pay some bills because they're grandparents, and they were helping with daycare. But the child went home, was with dad every night, dad on the weekends and everything else. Dad was an electrician for a Department of Defense contractor, and so he had a good job. But mom was, she was on a bender most of the time. So he was handling everything himself with her parents' help. And so her parents at one point decided that they needed to intervene because they wanted to take over primary custody. And so typically what would happen?
Well, so I'll tell you, the general rule is that for anyone to intervene, including grandparents, you're gonna have to have what's called a significant impairment, or, and you're gonna have a question of parental fitness. In other words, what the grandparents are gonna have to prove, is that frankly, for whatever reasons, both of these parents are unfit, and that they need to have that decision-making authority in the possession and access, as a result of that. And I didn't get much of a chance to look over the fact pattern. In this fact pattern, I think what grandparents are gonna have to go in there and argue is that clearly mom is unfit because her drug addiction. And then I think they're gonna have to argue that dad's fitness is called into question because of his inability or unwillingness, to basically make sure that the child is kept safe from mom during her drug addiction.
Now, the unfitness test is a really big deal because what we're talking about, and people can Google this if they're bored or whatever. Do not chat GPT it, I suppose, but so we had a whole thing about that. But really, we're talking about the parental preference doctrine, and it's an important court case because a lot of people don't know about it in Texas. I have personally taken this issue to the Court of Appeals and won. And the reason why it's so important is because everybody gets so caught up in the idea of, well, whatever's best for the kid, whatever's in the best interest of the kid, and people get so caught up in the statement of it's the best interest of the child that matter, they forget to, read the law.
Under the family code and under the Texas Constitution.
And the federal constitution.
What the parental preference or parental presumption is it says that, well, put simply, we're not going to allow government interference in a fit parent's decision-making authority. In other words, if a fit parent doesn't want to say, let their kids see their grandparents, or wants to, the fit parent gets to choose who cares for their children, who sees their children, who are around their children. That's just an example. So for a government entity, say a court, to step in and circumvent that parent's decision-making authority, we have to find that parent is unfit under law.
And there has to be a formal adjudication.
Right.
Is the requirement, and which is hard, by the way. A
It's
lot
not
of courts are not willing to do it. And what's interesting about this particular fact pattern is this girl's parents would have had to prove that she was an unfit parent. And the reason that's relevant is a lot of parents don't want to do that to their own kids, even if it's true.
Right.
Is proving up an unfit parent merely just a fact analysis? Are there factors? Like what are the type of facts that we want to know?
It's a fact analysis.
So it'd be things like ability to support themselves, income, job.
No,
What kind of things are
really,
you looking at?
number one on the list, drugs.
Drugs and alcohol.
Drugs and alcohol, obviously, any type of abuse, neglect. If, a lot of times in these types of cases, CPS has been involved. But, again, it is a fact-specific analysis, but in my experience, you're talking physical abuse, you're talking neglect, maybe emotional abuse. That's a little bit tougher to prove, obviously. And then, drug and alcohol addiction is a big one.
I think it's
For
probably
the dad's factor.
That's for me. That's been the number one in my
No,
experience.
I'm the same. And to answer your question though, Brian, this is a very good question that I've actually had to address in court before. It's not against the law or a showing of unfitness if somebody's poor. And so a lot of people want to get caught up in that. Todd's been with me in court on some CPS cases where basically they're like, we're going to take your kids because you're poor. That's not illegal. And that's not okay.
Yeah.
Right. And so the factors don't weigh a lot with their ability to support themselves because they always have fallbacks, whether it be state social assistance programs, equalization of money, especially during divorce or things like that. James?
Well, I was saying for this fact pattern itself, I mean, you had the police come at 2 a.m. because mom was on a tirade, and that's when eventually John, the dad here, he filed for divorce. And then you have also some drug testing happening. Mom is an outpatient for amphetamines, and she apparently also, I think she relapsed as well. So then here, the grandparents take care of the kid while the dad's at work.
Right.
So that's the grandparents, like if they want to try to choose unfitness, one, they have, like you said, you have to go after your own daughter. whether you're right or wrong, it's very unlikely you're going to be willing to do that. But against dad, it's, well, he works. Well, how else is he supposed to make money? He's letting you be childcare. He's to save some money. He's in the middle of divorce right now, and he's in other factor. He's kind of letting you see the kid.
Yep.
I mean, I thought that was a good thing, but now you're trying to use it against him.
I mean, with this fact pattern, I don't think grandparents are allowed to stay in.
Right. I agree. That's not what I put in here when I wrote it, just to be the devil's advocate here, but my experience has been they would have a snowball's chance of staying in this case.
I'm sorry if I was spoiling the ending.
No, he's
No,
already
no, no.
I should have put spoiler warning in.
I narrated this whole thing at the beginning, so
Okay.
so everybody's kind of familiar with the fact pattern.
He just gave it a sidewinder. Judge decided to go one way or the other.
No, I in certain counties, I've had fact pattern that wasn't even this egregious, where grandparents were allowed to stay in a case. I mean, so it's hard to deal with. I mean, you have some judges that are just more inclined to let the grandparents stay in and let's just see how it plays out.
Which is exactly what happened here.
Right. That does not surprise me, and I think that's a very accurate fact pattern because I've seen it happen more than once.
Like, maybe you're right, but let's just see where the dust settles, kind of thing.
In a case that I'm thinking of from many moons ago, husband and wife were going through a divorce. Wife made allegations of physical abuse against husband, not related to the kids, just related to her. She was advised by someone at Family Court Services in this small town county that I don't practice in anymore, that she needed to go talk to somebody at the AG's office and file for a protective order. The people at or not the AG's office, the DA's office. People at the DA's office contacted CPS. The first thing they did was drug test everybody. She tested positive for marijuana. Grandparents intervened, and they were allowed to stay in the case to the bitter end. So you had marijuana use and alleged physical abuse, and that was enough for this judge to not only allow grandparents to stay in, but in temporary orders award them temporary sole managing or joint managing conservatorship.
That brings up a side point, because I've seen it in a few different multiple hearings. In Texas, marijuana is still illegal. So
Yeah.
if you test positive for it, it's like, well, it's just a little bit of weed. Well, from a judge's standpoint, you show me illegality. That's what you show me. So it's not really in your favor.
Make sure you have a judge who also smokes weed.
There's more truth to that.
So let me back you guys up as the civil lawyer who doesn't do family law. When you say stay in the case, is it the court that would say grandparents you no longer belong in the case, or does some party have to affirmatively seek their dismissal from the
Great
case?
question. I guess a court could probably sua sponte do that, but normally it's going to be a challenge. Is one of the primary parties. What you're going to want to do is file a motion to strike their initial pleading, or in a motion to strike and dismiss, to basically have them booted out of the case.
So in our fact pattern, either the husband or wife, their attorney would.
Either, right.
Okay.
They should have followed up with the court and got them kicked out of the case.
That's what I do on day one. File a motion to strike and dismiss, and I write it all out with all the parental presumption stuff, and lack of significant impairment, lack of parental unfitness. And I throw all that in the pleading and file it. Once you've done it once, you've got a nice template for the rest of it.
And that's what John did in our fact pattern hearing. He struck them, arguing that they didn't have standing. But as Josh pointed out already, and as the narrative already said, that didn't work.
Well, it should legally they didn't have standing.
Right.
But that it's important that people understand that sometimes, just because that's what the law says, that's not always what happens, especially in custody and family law cases. And it's infuriating because it takes all the predictability from an attorney standpoint, takes it completely out of our hands. Because all we have is the law to go off of, and especially parental preference doctrine. I bet Jason and I could name 4 cases off the top of our head. Right? In Rec, we've got Troxel, we've got Carroll, we've got all these different cases that specifically talk about grandparents' rights, that talk about the parental preference doctrine, and everything else. And it's so clear, it's scary. But sometimes when you present it to a court, you have CPS lawyers there, or you have the other attorneys, they act like they've never even heard of the parental preference doctrine. And I had a case down in Clampettsville or whatever it was, Crockett. And there was a case that went on for 2 years. And I think we talked about this in one of the episodes already, but the case was going on for 2 years, and it was a custody case. I took over the case, and this is another one that sounds kind of weird, but I took over the case, and within 2 weeks we had a hearing, and mom went from supervised visit 1 hour a week to primary custodian. And the reason why is because dad worked in the oil fields. He had left this child in the care of his ex-wife for years, to the extent where the ex-wife was telling this kid that his bio mom was just a family friend, and that she was her kid, not even bio dad's kid. She was the only one on school records, pickup lists, and everything else. And so I got in and I argued the parental preference doctrine right away. The judge actually said, on the record, I will never understand why the other two attorneys that were on this case before didn't bring this up. I've been waiting for somebody to bring this up. I have to rule in favor of the mother. This child is going with mom, full custody right now. Yeah. And it was just one of those things where people thought it was okay and there was nothing they could do. And we had seasons that the attorney I took the case from had been practicing for 40 years, literally. And so you have things like that. It's just very frustrating to take over, RJ.
Well, I think it's important. I just want to make sure that this doesn't get missed. For anybody who's watching this, hearing this fact pattern, and hearing us talk about it, there are two things that I think are really important we mentioned. Number one, just because you have a problem with drugs or alcohol, okay, does not mean that the court is going to say you're an unfit parent and allow someone to take your kids from you. I believe what the court is going to want to see is they're going to want to see someone who acknowledges that they're having some difficulties, and they're going to want to see someone who goes through the proper processes to get help for their addictions. It's not a hopeless situation if you have a drug or alcohol problem. When you get into trouble and when parental unfitness or parental fitness becomes an issue is when you don't address the problems that you're having. Okay, so I want to make sure that that's clear. Just it's not hopeless. You just need to do what you need to do to get yourself right, and this can be handled. Okay. The other piece is, if you get to the point where the court does find that you are an unfit parent, and let's say awards primary conservatorship to a third party, say grandparents, you still have an opportunity to go get your stuff together, to get yourself cleaned up, to get on the right path. And an attorney can help you come in after the fact and rehabilitate your parental fitness. I've done that before. I've had clients who were adjudicated as unfit parents, who had their kids taken from them. I had a client who got a total sum of, I think, 2 hours every other Saturday in a public place with their kids. But he did what he needed to do. He had a steady job, he had a good relationship, a great new wife, and he had been clean for a substantial amount of time. He did what he needed to do, because this was his rock bottom, this was his wake-up call, and we were able to go in there and modify the order. It took a while, but we were able to modify the order, and he went from 2 hours a couple of times a month to being sole managing conservator of his 2 young sons. So, yeah, maybe I wanted to be the ray of sunshine. I know me, right? but you know, it's about moving in the right direction. It's about taking care of the areas of problem that you have. It's never hopeless. There's always an opportunity to turn things around if you're willing to take the steps.
Well, I mean, like you're saying, I mean, you could even have your client, you could be the wife's side in this situation, and you can just be honest, like, we're going to do a step up and explain what that means immediately. And if you can do a drug test once a week and show that she hasn't been doing it, it's consistently going down. Yes, it's still popping, but it's consistently going down, showing she's in the right steps, that can show a judge like, well, you're obviously showing some kind of progress, even if it's not exactly where I want you to be right now. It's showing, because if you've done it for, in this fact pattern, a few years, it's gonna be very much in your system. But if you show it consistently going down week after week, that's a good progression.
And that's what, after the final trial, I put in
So
that she got the step up.
Yeah.
Sobriety
Because
plan.
as mom's attorney, sometimes the best advice you can give her is, you don't need to see your kid right now, or we need to do a slow step up, because it's not punitive. You know, you say, well, I'm not advocating for her because I'm not pushing for as much, but if she's in a bad mental place, if she's actively using drugs, I mean, is it gonna be to her benefit or the child's benefit if I go in and I get her unsupervised access and she uses a bunch of meth and the kid gets hurt? I mean, she's gonna be in a lot worse position, and God forbid, the kid's gonna be in a lot worse position, or hurt, or maimed, or killed. And so, just because I'm advising a client, maybe now is not the right time for you to have unrestricted access to the child, it doesn't mean I'm not advocating for her. Maybe I'm advocating for her better than I would be if I was pushing for more access. And that's something I think as attorney, it's a tough part of our job, because you really have to evaluate that. You have to tell the client some tough things that they may not want to hear, but will ultimately result in a much better outcome on the backside.
Yeah, and I believe also that's one of those things where experience is worth a lot. Because then you can talk to that client and you're gonna be like, look, Melissa, I think that was her name, right? Look, Melissa, like, this is gonna hurt for a little while, but we're gonna get you back to a place where you're gonna be able to have full custody. We're gonna get you back to a place where you don't have to be looking over your shoulder. You're not gonna be dependent on drugs anymore. You're gonna be able to go on with your life. And that is the key here, because as we went through, I wanna talk about two more things before we finish, but as we went through this fact pattern, one of the things everybody has to understand is none of this is ever set in stone. And that drives people crazy. Like in a civil case, Brian, like you finish a case, you finish the case. Might go on appeals, great, but when the case is done, it's done. In a family law case, custody cases are always modifiable.
Mm-hmm.
And so we have a case that came in, I wish I could make this up. We had a case come in, the kid's 18 years old, but he's still in high school, and so the parent wants to modify child support of this 18-year-old kid, and custody, actually, but that's a whole different ball of nightmare. But they're fighting about child support, and it's a $220 a month child support obligation for this 18-year-old kid, but the parties can't even come to an agreement about it. And the kid's still in high school, they can't even come to an agreement about where he wants to live. It's bananas to me. He's an adult already legally. And these people
walk out the door, they can't do a thing about it.
these people are throwing tens of thousands of dollars at this problem, like the kid's 3 years old and he's going to be the next Einstein. I mean, it's just fascinating to me that people are willing to do things like this and fight about it, when what's going to happen, and Jay might disagree with me, James might disagree with me, but what should happen is the court's going to convene, this kid's going to walk into court and talk to the judge and be like, I don't really want to live with either one of them at this point, probably. But what he'll probably say is, I want to live with dad, or I want to live with mom. And that's what the court's going to do.
Yeah, I graduate in May. It's going to be a problem for January, for 4 more months,
Yeah.
Judge.
Actually, in this case in particular, without divulging too much, I think that there might be a situation where you have a child who is legally over the age 18, but there's enough manipulation going on one side that I think it might just be helpful for this child to be in the courtroom and hear it's okay for you. You don't have to stay here. You're 18 years old now. You can move freely between your parents' homes, or God forbid you're 18, go get a job, get your own home, right?
Yep.
And I think that sometimes it's just about passing that message along, and that's what might be important to, the parent who doesn't feel like they have the ear of influence over the child.
Now, one of the last things I want to bring up here is therapists and their role in family law cases.
I'd be interested to know.
What do you mean?
Therapists kind of run the gamut. I've worked with some really great therapists who I think have a really good understanding of what I think their role should be, and that's to, well, I mean, ensure that the child is coping properly with these transitions and the things that are going on, to listen to the child, to try to get to the bottom of what issues the child may be having, and spot those red flags. But you know, therapists run the gamut as far as, you know, how much they kind of try to interject into the case, and you know, they just all have wildly different approaches. And so, unless it's somebody that I've worked with before, I always feel like it's a little bit of a coin flip. Like, is, you know, getting counseling gonna help us, hurt us, or is it just going to muddy the waters?
Well, it goes back to what Brian was saying earlier about the expert. That is an expert. That is someone who is trained to do this right here and is hearing it from that person's perspective. So I can understand how I can kind of run the gamut, because the judge is not going to step in the way of, well, I wasn't in that room. I can have a 5-minute conversation with the kid or the parent or whatever, but I can't really take it. I'm taking him or her as face value because they know better than I do. I'm a judge. I'm not a therapist.
Well, the problem that you run into, and I'm sure this has never happened to you gentlemen,
Not me.
100% of the time it happens, is one of the parties decides that the therapist is against them, or the amicus is against
Always.
them, or the custody evaluator is against them, or the judge is against them, or anything else. And I think that's what's important for people to understand a couple things. Number one, most people don't care about your case. And I know that's kind of shocking for some people to hear, but for the most part, unless you just got a massive turd of a case, judges will forget your case before they get back to chambers. Now, that's the first part. Second part, sometimes they don't forget your case. And if they don't, that's a problem. Because a lot of the judges, the average caseload in Dallas County is, I want to say, isn't it 4,000 cases per judge, something like that?
Got me, but that doesn't surprise me.
And I think in Collin County it's two or 2,500 or something like that.
Something like that.
That's a lot of stuff for a judge to remember, right? Now, attorneys, our average caseload, depending on the law firm, right? The average caseload per family law attorney is probably anywhere between 50 and 100. We'll call that the average. I know a lot of law firms are like, oh, I carry 200 cases, or I carry 150, whatever. I'm just giving an average, all right? It's easier for the attorney to remember the meat and potatoes about what's going on. If the judge recognizes the parties, that's usually not a good sign.
Yeah.
If the judge is looking at a case and says, oh, I remember this.
You said some magic words. I remember.
Yeah.
I had
Unless
one.
you've got the client the judge likes.
That's the difference. That's the point I'm getting to.
Because normally, yeah, the judge will remember it because of the party they don't like. As long as that's not your client, you're okay.
Exactly right. And as long as you're not the client, that's okay. And that's kind of what I'm getting to my point. So if you're going through a therapist or a custody evaluation or anything else, one of the most definitive ways to get on everybody's bad side is to do nothing but attack the other party.
Right.
Do not go in there just like, this person's the Antichrist, you need to burn them to the ground. You don't do that. If you go in for an interview with a therapist or custody evaluator or even an amicus, because I've done all of these things, don't let your client just bash and name call and attack the other party for 35, 45 minutes. And the reason why is because the focus should always be about the child. Now, if there's always going to be context. Context is key in basically every situation. So you have to give context, but you have to give some deference in your context too. Don't just attack. And you have to coach the clients, and the clients have to understand that if you just consistently attack somebody and try to make them look bad, it actually makes you look bad.
Can I give 30 seconds of free legal advice?
Please do.
Well, I had
This free legal advice coming to you from Jason Nauman.
I had a client do this once, and I thought it was brilliant, and I've instructed many clients since to do it. I had a client who was meeting with Family Court Services for the child and custody evaluation. But I think this could be applied to counseling, especially reunification counseling, across the board, CPS even. But especially with the child custody evaluation, they had a bunch of concerns about the other parent. And so what we decided to have the client do was to write down all her concerns about that, right? Write it all down, write it out. Every concern you have, all the things you think he's done wrong, all the bad things you think he does, how you think he's screwing up the kid. And when the family court services person shows up for the interview and to meet you and see your home, give them that page and then spend your entire time talking with them about all the great things you're doing with your kid, how great your kid's doing, and spend, like you said, you want to spend your time focusing on the good stuff, the stuff, your relationship with the child. And I find that that's really a good way to get that client focused in on talking about the things that are really going to help them with that evaluator, is write down those concerns, pass them along. That way they feel like they're being heard, and
Right.
they feel like it's, that they conveyed all those things, and it's usually a little bit more coherent than listening to them ramble about how much they hate the other side anyway.
And that person is now gonna probably see those concerns in a different light. It's like, oh,
Yeah,
she was a pleasant person. Okay, maybe she has a
Yeah.
point here.
She's yeah, they're seeing that client or that parent at their best, because they're seeing them interact with a kid. I mean, that's the good stuff. And they don't seem like this bitter kind of angry person. But then, they can take it back and they can review those. Oh, well, yeah, that's a concern, and maybe address it with the other side, which is probably going to get them on the defensive, and
Could work in
you
your
see,
favor.
you see what I'm saying? Strategically, it's just not a bad idea. So I recommend all clients do that now.
I like that.
If you have concerns, write them down ahead of time and don't bring them up at all during the meeting.
Just-
There's no need to.
Just focus on, well, this is the child's pattern, this is what I do to try to help them. They're struggling with this part in school, and this is what we're doing. The soccer practice, they're not the best kickers, we're practicing goal kicks, we're practicing tackling, or whatever. We got a private coach, we got this, or I can't afford a private coach, so I watched YouTube videos and I'm trying to teach them how to bowl, or whatever. It doesn't matter, but
Courts really listen to those evaluators, and
Yeah.
the child custody evaluation, I mean, the court puts a lot of weight on that. And so you've got a very limited amount of time to convey to this person what type of parent you are, and all these great things that you're doing with the kid and how great your kid is doing. Use that time for that purpose, and it's going to benefit you in the long run.
we're switching some mics around here.
I think it kind of highlights we are working a law office, so we can't just always
Yeah.
shut down for an hour.
So, I really think people need to understand the weight of a couple things here. We've had plenty of custody cases where we have all the facts, everything totally lined up, we think we knock it out of the park, and then the judge will go and talk to the child in chambers. And, if your kid's basically 14 or over, they can do their talking with walking, or do their talking with their feet. It's a pretty common way of putting things. Of if the child doesn't want to be with mom or child doesn't want to be with dad, the big threat when they get older is they're going to run away. And so it's 14 in Texas, but it can be younger. I mean, courts really take into account a lot of child's wishes. And so it doesn't matter how good your case is. If your kid goes in and says, look, I love my dad, love my mom, I just don't want to live with my mom.
Right.
No amount of legal wrangling on the planet is really going to be that effective to get around unless you can truly prove coaching. Now, if you can, but how do you prove that? I mean, and look, I've tried, and I've been borderline successful at proving that, because I've had text messages. Jason was in court recently where they had text messages and phone calls with the dad freely talking about the case and talking crap about the
Well,
mom.
he admitted it on the stand.
And he admitted on the stand.
It was coaching.
Mhm.
I mean, there was no way around it.
And it didn't matter.
And it didn't matter.
Jeez.
And that's not what the law says. I mean,
Your head didn't explode, did it?
It did a little
Almost.
bit, because I mean, the law says that that the court is required. The court shall interview a child over the age of 12 on the request of one of the parties, or the court can do it sua sponte. What the law says is that with the contents of that interview, what the child says is a factor that the court is supposed to consider.
Mhm.
But it doesn't. I mean, there's
That's not the
there-
be all end all.
Well, but there's nowhere in the code where it says you assign this value to it, or it's this percentage. Well, we're giving it this much weight, and so it is. It's subjective, and fortunately or unfortunately, as the case may be, I think courts put a lot of weight into those interviews, and I routinely tell clients when we're talking about those interviews that you live or die by this interview.
Yep.
If we think that the child is going to say that he or she wants to live with you, then we request the interview. If not, we hope they don't, right? Because that's
Because
the
they,
reality of the
they
situation.
expect lawyers to spin the best facts one way or the other for your client. That's a given. But when it comes to a child, it's like, unless, like you just said, unless you can prove and actually prove coaching and they care about it. It's gonna be, like, what that child says or what that evaluator says, it's like you said, make or break.
Well,
Because they're not here to spin it one way or the other. Just here's like, here are the facts that I got. Here you go, judge. You make your call from there.
Well, I think this is one of the reasons it's important to have even judges that are familiar with family law, which is tricky sometimes in Texas because we have a lot of general jurisdiction judges. And so maybe this particular judge doesn't really have a lot of expertise with kids that have been coached, right? So then you have to spend your time in court. If you're smart, you're going to spend your time in court educating the court about what it looks like and what it is. And here's a good example. It's kind of a side note. Todd, I want you to chime in on this because I know for a fact you've heard me do this. One of the things that happens a lot of cases are domestic violence cases. We've all had them, right? We've all represented an abused spouse. 100%. I know for a fact all four of us have done that, right?
Yep.
The problem is, and this happens more than people want to admit, is people forget to take into account some of the symptomology of a victim of domestic violence.
Mm-hmm.
And so you'll hear a court, you'll hear an attorney. Sometimes, if you really have bad luck, you'll even hear an amicus say, well, I'll just say I'm representing the wife who is a battered individual, right? You'll hear them say, well, I mean, it must not have been that big of a deal because she didn't call the police or she didn't call CPS or she didn't do anything for it.
Right.
And that's one of the main issues with systemic domestic violence, right? People being put on an island, the predator exerts almost complete control over their life financially, socially, with the family, everything. And so
Where else is she supposed to go?
she can't, right? There's nowhere for her to go because that's how psychologically, that's exactly how she's made to feel. And Todd, what has been, if you remember off the top of your head, I don't know if you do, I presume you do, but when I've had to educate lawyers and judges about that situation in court, what has been the reaction typically?
Well, I feel like you usually go through a history of the battered spouse syndrome, and I don't know. I guess I would assume the average reaction is they're unaware of this subject or this phenomena.
Shock and surprise?
Right.
Yeah.
Shock and
What do you
surprise.
mean?
Right.
Like, how is this a thing?
Look, I've never heard of this before.
And that's shocking to me.
But fortunately, when you explain it to them, it makes a lot of sense. You know, it's not a concept that's just so foreign that they can't wrap their heads around it. These people, when they're in a situation where there's systemic abuse, I mean, unless you've been in that situation before, you really can't understand it. And I will say fortunately, I've fortunately been privileged to represent a number of clients who have been the victims of abuse. I say fortunately because I like being able to advocate for them and get them a good result to keep them and their kids safe. That's one of the few feel-good moments we have. But the fact that they keep going back, the fact that they don't reach out to the authorities, the fact it's because they're so conditioned, I think.
Well, it wasn't as bad as the last time, so it was just one hit this time. He didn't, beat me down. It's
even
still a hit.
Even more than that, I think it almost becomes a sense of security to them. They're almost maybe it's like the devil, like,
Yeah.
Well, he's beating me, but for all the reasons he's doing it, I couldn't survive on the outside. I need this. You have that attachment.
Like,
Stockholm
I'll
syndrome.
throw out another sort of sad justification I've heard from clients, which is that even if I obtain this protective order or TRO, how's that piece of paper going to stop him from coming over? And what if the police don't show up in time, or what if the police don't answer the call?
I think some of them are genuinely worried about escalation.
Right.
And the problem is we're kind of inundated in the news with these things. Where family violence it tends to escalate.
Yeah.
It's always a downward spiral.
That first slap may have been a big deal, but it's a little bit easier the next time. And then it gets worse, and it gets worse. And that's what I try to tell people, like, listen, it's just going to get worse. It's not going to get better.
And I'm going to interject, sorry. It's also a 100% recidivism issue.
Yeah.
So if it happens once, is it 100% guarantee it's going to happen again?
Right.
And that's not me making that up. That's me. I've studied and fought against domestic life for my entire adult life. I was a domestic violence detective, as a police officer. I've studied it. My doctoral dissertation was literally on the battered spouse syndrome. I've helped set up domestic violence courts in different jurisdictions. I've argued protective orders. I've done tens of thousands of hearings specifically about domestic violence. And now I am tenured as an expert in 5 different states about domestic violence. And the problem that people just fail to understand is how real it is. And it is both ways. It's men get abused, and it's a lot more embarrassing for a man to be abused, even in 2026. If you have a male victim who the wife has been beating on or threatening and doing all the things, it's to this day, it's still a little bit more hard for people to buy that the man is getting abused than the woman, because they're like, well, Jason, you're 3 times the size of that person. Why couldn't you just stand up for yourself and make it stop?
And I agree, it is embarrassing to be abused.
But the reality is it's psychologically different, because this is all about control. The abuser 100% of the time is all about control. That's why personally I think domestic violence is one of the worst things that you can do to another human.
Yep.
Because you take their liberty, you take their self-confidence, you take their personality, you take everything from that person. Everything that they are, you take from them. And you make them believe they're not worth regular love. You make them believe that they're not okay. You make them believe that they're totally beholden to the abuser. And it is a terrible, spiteful, manipulative condition that they are relegated to live in. And even when I talk about it and I deal with it every day of my life, I get angry, just as passionate and just as angry about it, because it is something that we as lawyers, or we as law enforcement, or we as whatever role we're in at the time, we have to deal with it. And then you're dealing with people, just like Jason was talking about, and Todd, you have to deal with people that, despite the fact they're in the same stupid profession we are, they act like they've never heard of it. They act like they've never, half the time they've acted like, well, what do you mean? I've literally had people say, well, why did she say this? I'm like, he was threatening to kill her. He just put her son in the hospital. His stepson, her son, put him in the hospital. He's threatening to kill her. She would have said anything humanly possible to stay out of trouble with him. Because to her, a couple things. Security is everything. So she will say and do anything she possibly can to stay out of trouble, as she sees it, to stay safe, or as safe as she can be. And then number 2, he can tell her and manipulate her to say almost anything.
Well, I mean, what you just said earlier, you're talking about how the abuser, they tear down the individual in every way. Well, that's why they stay, because they're torn down to the point that they just don't have the self-worth, the self-confidence to make those changes. But you talk about other attorneys in our business. I mean, I think that it kind of rolls back to what we were talking about earlier with the mom who's using drugs and maybe not okay to see the kids. Sometimes as attorneys we have to say, is fighting for the sake of fighting, or fighting just because we can. Go in there and look at the abuse victim on the stand and try to make a fool of her or him. And you go, well, why didn't you call the police? So it couldn't have been that bad. Listen, sometimes advocating for your client doesn't mean that you are ripping up the other side. My goal is always to help make the situation better. And that may mean having a tough conversation with my client, not just about drug use. Maybe it's about, hey, you need to get some counseling because I think you've got some problems with your anger, and I think that you're doing some things that I mean, it's not who you are, you're better than that. Maybe let's talk about some different avenues that we can take to get you the help so you can have a healthier relationship. If it's not with this person, with the next person.
All right. I know we've been going on for a while. I'm gonna just kind of finish out here real quick. If you find yourself in these positions, absolutely call an attorney. Go sit down and talk to an attorney. Make sure you can get along with that attorney and you drive with that individual. But make sure more than anything you be honest, right? One of the hardest things in a custody case is if in the middle of a custody case somebody gets a DWI or somebody gets a drug arrest or something like that. you got to be straightforward about where you're coming from. Be straightforward about the issues that you're fighting with, the demons that you're battling, because all this stuff is going to come up, especially in a divorce with a custody case. Literally everything that you never thought would see the light will see the light. So it's going to be. We had a client the other day. We were talking about their text messages were subpoenaed, and whether it was funny or unfunny at the time, like the text messages, all their text messages from their cell phone went to the court, all of them. And so I don't even have to go into detail what that meant. You can imagine.
That wasn't a client, it was me. It wasn't a client, it was me.
All of those
So
text
we got that.
messages,
Turns out I
everything
like
went. But I mean, you just have to remember that's why honesty with your attorney, honesty with yourself, and I'm going to end with this, right? We are responsible for our own salvation, right? I promise I'm still writing that book. Nobody's coming to save you, right? I've been working on it for a long time. Todd, how long is the outline on it? I think the outline is 87 pages long for this book, right? And it is very true. Nobody is coming to save you. Expect self-rescue, right? That was beaten into my head in training. It's been beaten into my head as an adult, and it's been beaten into my head the more I learn, the more I've studied is we are responsible for ourselves and our actions in this life. And if you're religious, in the Bible it says we are responsible for wreaking out our own salvation with God, right? Nobody is going to intervene with us and say, hey, James isn't going to come and testify. Josh really is a good guy. Sorry he murdered those kids or whatever. That's not it, right? I'm responsible for my relationship with God. I'm responsible for my relationship with my kids. I'm responsible for my relationship with myself. And so nobody's going to be able to save you from yourself in a lot of these instances. You have to be the one. You have to be the force of change. So if there's something that is adversely affecting you, or adversely affecting your kids, adversely affecting your spouse, whatever the case is, you have to be mature enough to stand up and put an end to it. And heaven forbid you're the one going through the domestic violence relationship and you're the one being abused. This is a very hard pill for a lot of people to swallow. I have personally removed many people from domestic violence relationships. As a police officer, in the military, and as an attorney, and as a friend, I have physically carried people out of these relationships. That is few and far between. More often than not, it's going to come down to somebody has to decide enough is enough, my life, and I'm worth more than this. I'm not garbage, I'm not bad, I'm not all these things that I've been made to believe. My life is worth something. I have to stand up and I have to run and I have to get away from the situation. And we can post in the show notes all the numbers for all the things that you need for shelters and everything else, because there are just a ton of resources for you. But if you don't know where to go or where to call us.
And the first step is the most difficult one.
Yeah.
Making the decision to get help, that really is the toughest step. Once you make that first step, you'll start to feel better quickly.
Because then you start to feel like you are a little bit more human, that your happiness matters, that your life matters, that you're not being selfish just because you want to be happy. You're not being selfish just because you don't want to get beaten. These are all things that are hard, and these are real situations, and they're real, honest cases. So no one is coming to save you. Expect self-rescue is the motto that I am living by and have lived by for a couple of years now. And I hope that some of this, as we go through all these cases and kind of this case, we talked about a lot of different things. And I hope this finds someone out there a lot of help and a lot of guidance. If you need help, call us. Obviously, 972-455-8700. Or if you're in the state of Texas, 1-800-DIVORCE. Pretty easy number to remember. Anything else you need, and if you don't know where to go or anything else, call us anyway. We can point you in the right direction. We know shelters. We know people who can help. There are organizations that can help and guide you and everything else. And the same thing if it's a drug issue, it's an alcohol issue, whatever you need, reach out and help us help you, or help somebody help you, because it's going to be on you to take that first step. But once you start taking those first few steps, other people are going to reach in and they're going to be able to help you out. You're never alone. Go ahead, Jay.
Same thing goes for drug and alcohol issues.
Yes.
Not just about abuse, but our case kind of focused on those. Heed what we said earlier. It's not the end of the road until it's the end of the road. There's always room to get help. There's always time to make the situation better. You just have to take those first steps.
All right. All right, everybody. That's episode 12, I believe, of the Associates Data Podcast. We appreciate your help and support. As usual, this was written mainly by Josh Carpenter. It was directed by Todd Cohen, the extraordinaire. It's also edited by Todd Cohen. And
Produced by Todd Cohen.
produced by Todd Cohen.
Wait,
Massaged and
is it
loved by
recorded?
Todd Cohen. And we hope you keep tuning in. If you have any comments or anything else, please let us know. We look forward to hearing from you. And until the next.
Yeah, you know who it is. Hey, don't ask who did it. Check the name, fool. The associates did it, yeah, they rolling deep.